Welcome to the Battling the Big Bad Baby Bar, and welcome aboard. First essay we're going to do, or I should say the essay we're going to do today, is question number 3. And as with all questions, we begin with something called the call of the question, which we will call the COTQ. Beginning with the COTQ, we read, with what crimes can Doug reasonably be charged? What defenses, if any, may he reasonably raise? And what is the likely result? Discuss. Well, right here, bar applicants, we're seeing that the word crimes should absolutely be calling to our attention something. Well, what is that something? Our area of law called criminal law. And with a criminal law, with our area of law being criminal law, we should have a shopping list, or some call it a checklist. After we identify our area of law, we put down our checklist or our shopping list. The one that you supply will be personal to you or to your bar review program. What we have is murder, structure, theft, crimes against the person, solicitation, conspiracy, attempt, and defenses. Well, you might be asking, why am I only doing one letter? Well, during time management situations, it's very important to keep an idea that you're under that 60-minute pressure, okay? And so the more words you put down, the less time you can actually apply to your paper and get those most precious time and points in your analysis. So I guess what I'm trying to say, the less time we spend outlining and the more time we spend in our analysis, the better chances we have on getting more points. And that's why when we're outlining pre-essay, we want to get our shopping list or our checklist down to minimal parts. M being for murder, S being for structure, T being for theft, CAP being for crimes against the person, S/C being for solicitation conspiracy, A being for attempted crimes, and D for defenses. Okay, with that being talked about, let's go up and read our question. Excuse me, which we will call the Q. In the Q, we read, Doug decided to tell Bob, the owner of a small grocery store, because Bob had twice falsely accused Doug of shoplifting. Doug went into Bob's store and killed Bob by shooting him twice with a handgun. After the shooting, Doug noticed the cash register, went over and opened it, and took all of the money out of it. Doug then saw a customer, Sally, hiding behind some shelves. He pointed the gun at Sally, took her purse, and tied her hands behind her back. Doug then heard police sirens and ordered Sally at gunpoint out of the store and into his car. Officer Fran, who was responding to a report of gunshots at Bob's store, saw Doug speed out of the out of the parking lot in his car. Officer Fran chased him for several blocks until Doug pulled into an empty parking lot. When he got out of his car, Doug fired several shots at Officer Fran, who responded by firing her gun at Doug. She missed Doug, but one of her bullets went through a window of the car and hit Sally, killing her. As Doug tried to run away, Officer Fran tackled him and knocked the gun from his hand. Doug got up and punched Officer Fran with his fist. Officer Fran then subdued and arrested Doug. With what crimes can Doug reasonably be charged? What defenses, if any, may he reasonably be raised? And what is the likely result? At this point, we should have all of the Q facts in our mind in what I like to call a movie mode, so that we can be able to see it in our mind when we go back through a second read and engage in what I like to call issue spotting. Doug now decided to kill Bob, the owner of a small grocery store, because Bob had twice falsely accused Doug of shoplifting. Right here, what is it we have yet? We have a person, Doug, the criminal defendant here, deciding to kill Bob, the owner of a small grocery store, because Bob had twice falsely accused Doug of shoplifting. Now, at this point, has there been any crime committed? Well, not necessarily. We have what in criminal law is like the mens rea, the mental state, but we don't have the accompanying actus reus yet. That should come in our next sentence, I think. Doug went into Bob's store and killed Bob by shooting him twice with a handgun. There we go. Right now, we have two things at least going on. We have Doug going into Bob's store, and we have Doug killing Bob, shooting him twice with a handgun. So now coming down, and as we're writing our paper, we should be, first of all, putting down our call the question in a user-friendly format. We're going to say crimes and defenses of Doug. That's going to be our user-friendly header, which is going to encompass everything concerning our COTQ. Also, with most importance, we want to make sure to address all parts of our COTQ. So with crimes and defenses, we've addressed that. And what is the likely result? We want to add an important header called conclusion. We'll talk about this when we get to it, but it's mainly a summary of all of the things that we've talked about, either for the positive or for the negative. In other words, we've proved them or they've been disproven. Now, down here, we want to make sure to put in an important header called State v. Doug. This is basically this header is called our conflict, and this will address who is suing who. Now to our issue spotting application to our facts. Okay, up here again, just to refresh our memory, we have Doug deciding to kill Bob, the owner of a small grocery store, because Bob had twice falsely accused Doug of shoplifting. Doug now went into Bob's store and killed Bob by shooting him twice with a handgun. Right here we have something we call burglary, because we have Doug entering Bob's store, but burglary of what? Burglary of Bob's store. And we will come back to this in a minute, but we're issue spotting right now. And as we issue spot, we're putting down issues. Now, issues by definition, in my definition, I should say, are legal terminology, legal concepts that are triggered by the facts. And so we're saying here, this fact of Doug going into Bob's store with his intent to kill Bob as technically triggering the issue of what? Burglary. And we'll come back to that here in a minute. And then Doug subsequently killing Bob by shooting him twice with a handgun. Well, what is that? Obviously, absolutely, you spotted it. It's the homicide of Bob. Our next set of issues here. Now, as we go through here, we want to make sure to keep this in our mind. As we're issue spotting, we're looking at our shopping list. Why are we continuing to look at our shopping list at the same time we're also looking at our facts? So that we don't forget to raise important issues that we might generally overlook. And like I always say, when we go into a shopping store without our shopping list, sometimes we might forget to get certain things. The same can be said for issues on an essay without a checklist or a shopping list. And that's why I keep an eye on my checklist while I'm looking at my facts, so that I'm making sure that I'm addressing every single issue that these facts could potentially raise. Now, after Doug shoots Bob kills Bob by shooting him twice with a handgun, Doug noticed the cash register. He went over and opened it and took all the money out of it. Or I should say this, he took all of the money out. And what issue should that be getting us to think about? Larceny, exactly. Very good. Larceny of what? Of the cash. Absolutely. Or we could say the money. We want to make sure to keep close to our facts as possible. That's why I changed cash out for money. Money was used in our fact pattern, or in the queue. Now, he pointed the gun at Sally, took her purse, or excuse me, I should say, Doug then saw a customer, Sally, hiding behind some shelves. He pointed the gun at Sally, took her purse, and tied her hands behind her back. At this point, what is it we have concerning Sally? Well, at least we have the aggravated, and we'll explain here about what aggravated is, aggravated assault. Well, what was the aggravated assault fact? It was when Doug pointed the gun at Sally. Now, when Doug pointed the gun at, or after Doug pointed the gun at Sally, he took her purse. What theft crime might this be? Absolutely. Robbery. Robbery of Sally. Now, down under here, we want to make sure to address the fact that Doug tied her hands behind her back. What is that? Absolutely, again, it's bad. It's aggravated. You might say aggravated because of the situation. It is an aggravating situation with the presence, in other words, with the presence of a deadly weapon, or some circumstance that has the deadly weapon force in play, creates aggravation. And it's not just regular assault or regular battery. It would be aggravated assault and aggravated battery. Okay. Now that we've addressed those particular facts, we move on to the next set of facts. Doug then heard police sirens and ordered Sally at gunpoint out of the store and into his car. You might be asking, how come I haven't talked about false imprisonment yet? Because sometimes false imprisonment can become something called exactly kidnapping. That's exactly what we have here. When Doug, hearing the police sirens, ordered Sally at gunpoint out of the store and into his car. That would be the movement, the false imprisonment plus the asportation of the movement is what we call, exactly right, kidnapping. Now, after going through those facts, we go down to the second paragraph. Officer Fran, who was responding to a report of gunshots at Bob's store, saw Doug speed out of the parking lot in his car. Officer Fran chased him for several blocks until Doug pulled into an empty parking lot. Well, stop right here. Let's ask ourselves this question. Why are the bar examiners supplying us with these additional set of foundational facts? Well, they will be helpful possibly to establish analysis for other issues. And mainly, if we keep this at the forefront, that we might be dealing with a felony murder rule situation. And this is indicating that indeed, Doug is still engaged in the perpetration. He hasn't entered a place of seeming safety or a safe harbor. These facts are all indicating that safe harbor has not been achieved. Why? Why do I say that? An officer is chasing Doug. When he got out of his car, Doug fired several shots at Officer Fran. Now, firing several shots at an officer or a person definitely could very well provoke an issue, okay? Trigger an issue. We should be sensitive to facts that trigger our issues. And these bullets that were fired by Doug at Officer Fran should trigger an issue of, absolutely, attempted murder. Of who? Officer Fran. And why do I say attempted murder rather than, excuse me here. There we go. Thank you for your patience. Why do I say attempted murder? Well, the bullets did not instantly kill Officer Fran. Now, they were shot at Officer Fran, and those bullets could have indeed caused Officer Fran's death, but they did not. And therefore, that's what constitutes the attempt. And also, the fact of the matter was that Doug had taken a substantial step in causing Officer Fran's death. And we'll go through all these elements as we go through the paper further, okay? Just pointing these out to you to indicate why I chose these particular issues from the facts. Now, this Officer Fran who responded by firing her gun at Doug. Now, this is a very interesting aspect because remember, one of our shopping list headers, or I should say topics, is defenses. At this point, we don't want to forget to raise self-defense. This is what Doug might be seeing from his perspective, that Officer Fran firing at him might provoke or might bring about the defense of self-defense, because Doug might be thinking that his life is imminently about to be taken by Officer Fran firing her gun at Doug. She missed Doug, but one of her bullets went through a window of the car and hit Sally, killing her. At this point, we should instantly be thinking, exactly right, homicide of Sally. Why? Because Sally has been killed by a bullet fired by Officer Fran. Homicide of Sally. And we'll get to the point here that and we'll explain how in felony murder, this particular homicide of Sally is not attributable to Officer Fran. It's not attributed to Officer Fran. It's actually it'll be charged to Doug. Doug will be liable for the homicide of Officer Fran. Why might you be saying this? Or I might be saying this? It's because Doug is engaged in a felony, and the felony being, you might say, well, which one felony? Mainly burglary, possibly robbery. The aspect is that he's fleeing now, and as a result of fleeing, Officer Fran fired a bullet at Doug in order to stop Doug, but that bullet hit Sally and caused Sally's death. This would not have even been at all. This wouldn't have happened at all, except for the fact that Doug is still engaging in the perpetration of the felony. He's fleeing from the scene. In other words, like we just said, he hasn't reached a place of safe harbor, and he is criminally liable for the death of Sally. As Doug tried to run away, Officer Fran tackled him and knocked the gun from his hand. Now, this could also be an aspect of his self-defense argument as well. Doug got up and punched Officer Fran with his fist. Now, this is where we should be thinking of our crimes against the person in our shopping list. I'll go zoom up right up to our shopping list. Crimes against the person. Keeping our shopping list fresh in our mind is of supreme importance. Now, what crime should this make us think when Doug got up and punched Officer Fran? Absolutely, battery of Officer Fran. Now down here, down here, when after Doug got up and punched Officer Fran with his fist, Officer Fran then subdued and arrested Doug. So this could very well be a situation. It's possible to throw in a misprison here, but I'm not going to do that because I don't believe that's a point gathering issue here from these sets of facts. Okay. Now with this being completed, now this is representative of our issue spotting issues. Okay, or after issue spotting, these should embody our issues. We have burglary of Bob's store, homicide of Bob, larceny of money, aggravated assault, robbery of Sally, aggravated battery, kidnapping, attempted murder of Officer Fran, self-defense, homicide of Sally, battery of Officer Fran, and this would be our conclusion, which would address the aspect in our COTQ of what result. Now, we can now be confident when we remove our shopping list from our screen that we've addressed all the issues from the facts, and we can now start addressing the particular elements of our issues. All right, excellent. Very nice. We want to make sure too that we do proper formatting if we have time. Excellent. Very good. Let me take the underline out of here. Okay, perfect. Okay. Now, burglary of Bob's store. Now, you might be asking yourself, aren't there two types of burglary? Absolutely there are. There's the common law burglary, which we ask ourselves here, is Doug's store a dwelling house? Like, well, first let's lay out what common law burglary is. It's the breaking and entering dwelling house of another at night with the intent to commit a felony therein. Well, we have some missing parts here, okay? I should say some missing elements. The store, a small grocery store, is not a dwelling house. And it doesn't indicate the time of day, so the at night aspect might be missing as well. Now, does this mean that we don't talk about common law burglary? Absolutely not. We note the elements that it's missing, and we then say that the common law burglary most likely applies, and then we address common law, or excuse me, after common law burglary doesn't apply, we address modern law burglary. Thank you for your patience. And under modern law burglary, it's an entry to the protected structure of another with the intent to commit a crime. This is more fitting to what we have. So I'll underline this one so that we can easily pull this out. This is the one that we are going to address in our elements, because what is it we have? We have Doug going into Bob's store. What? And is that store a protected structure? Absolutely. And what intent did Doug enter Bob's store with? The intent to kill him, and that is a crime. So Doug has fit all the requirements, all the elements he has satisfied for modern law burglary. Absolutely excellent job. Okay, now coming down to homicide of Bob, we have to ask ourselves here, after these facts up here are the ones we're going to be looking at. After Doug went into Bob's store, he killed Bob by shooting him twice with a handgun. Now, down here under homicide of Bob, did we need to lay out the definition of homicide? Homicide is the killing of a human being by a human being. Okay? Now, did Bob die at the hands of Doug? Absolutely. So we have a homicide of Bob by Doug. Now, do we have, so we want to make sure to throw down, we've addressed homicide. Have we dealt with the actual cause yet? But for the criminal actions of the defendant, the victim would not have died. Victim being here, Bob. But for Bob being shot twice with a handgun, but for Doug shooting Bob twice with a handgun, thank you for your patience, Doug would not have died. Absolutely. This is the but-for test, and that is satisfied. Proximate cause. Is it foreseeable that if someone shoots, if a criminal defendant shoots a victim twice with a handgun, that it is foreseeable that the victim may die? Absolutely. There's a foreseeable element here, and then it has been satisfied. Now, foreseeability. Make sure. Okay. Yes. Okay. Now, malice of forethought. This would represent the mental state. The actual cause and proximate homicide, actual cause and proximate cause would have represented our actus reus. Now, the malice of forethought has 4 parts to it. The first part being intent to kill. Do the facts clearly indicate to us that that Doug intended to kill Bob? Absolutely. He decided he was going to kill Bob when he entered the grocery store because supposedly Bob had twice falsely accused Doug of shoplifting. Okay, that might be raised as a mitigating factor later on, but right now we're just talking about whether or not Doug intended to kill Bob. Now, Doug then went into Bob's store and killed Bob by shooting him twice with a handgun. So we have, not only do we have expressed intent to kill, but even if we didn't have enough elements to prove up expressed intent to kill, or enough facts to prove up our element of expressed intent to kill, we could also prove it up by the deadly weapon doctrine because of the use of a deadly weapon, which would be implied intent to kill. Okay, now, is there a felony murder situation going on here? Well, see, we have to have, remember what the definition of a felony murder is. The definition is that there is a foreseeable homicide during the commission of an independent and inherently dangerous felony. Is the very same act that brought about Bob's death the very act that we would attribute to the felony? The felony is the very act that caused Bob's death, is the best way of saying that? Absolutely. So I don't see that there's a felony murder situation here. Now, on to the next Malice of Forethought state, intent to cause serious bodily harm, murder. Now, when this is technically the intent to cause serious bodily harm, murder is an intent to cause a bodily harm that leads to the murder, to the event that causes the death to the victim. Did Doug intend to shoot Bob? Absolutely. So I could very well say here, confidently say, that not only did that intent to kill Bob under number 1, I can also carry that intent down here to the intent to cause serious bodily harm, because that same element, intent, is shared between both the intent to kill and intent to cause serious bodily harm. So by his actions, Doug manifested intent to cause serious bodily harm, murder, to Bob. And number 4, depraved heart murder. And this would be like the reckless, reckless misconduct that disregards the value of the victim's life. Now, did Doug's shooting Bob twice in the shopping center, or in Bob's small grocery store, did that recklessly disregard the value of Bob's life? Absolutely it did. And not only Bob, but those around Bob as well. So this is absolutely 100% depraved heart murder. There you go. Perfect. Is satisfied. So we could actually have 3 out of these 4 would be present in Doug's shooting of Bob twice with a handgun. Now, down here under degrees, I want to make sure to point this out to you. There is first degree murder and second degree murder. Quickly point this out to you. Under second degree murder is residually defined as all malice aforethought states that are not in first degree or second degree. Now, first degree murder for intent to kill would involve the additional elements of premeditation and deliberation. Let me ask you here, did the fact that Doug decided to kill Bob, did that represent a premeditation? Now, premeditation being that he had a pre-thought out plan that he carried out. Absolutely. That is exactly what Doug intended to do. He intended to kill Bob because Bob had falsely accused him of what did the facts say here? Of shoplifting. Now, down under deliberation, did Doug carry this out in a cold, blooded type manner? In other words, he had a cool mind that he carried out this intent to kill or this homicide out with. Absolute. Well, you could say yes in one instance because he fired two shots at 2 shots with a handgun at Bob. You could argue that, but he probably was under some kind of heat. So you could say, well, maybe he had a cool mind. It's possible, but most likely he was still agitated about the fact that Bob had accused him falsely of shoplifting. So it's possible that we don't have deliberation here, but it's good to show your bar examiners that you're thinking about the issues and making creative arguments. Okay, and then also we want to make sure. Okay, after we talk about premeditation, deliberation, we don't have the felony murder rule situations here that would have the inherently dangerous felony elements. So we move on to our second degree murder, which would be we would have in our intent to kill, our intent to cause serious bodily harm murder, and our depraved heart murder would fit into this category. And so, even if the state would not be able to succeed in proving first degree murder of Doug through intent to kill murder, they could very well prove it through a second degree murder charge through intent to cause serious bodily harm murder and depraved heart murder. At this point, we also now want to throw in our defenses, okay? And we want to make sure that we are bringing up the aspect about, or I should say, we want to make sure we classify our defenses from our mitigating factors. I don't think here that Doug has any defenses right yet. We'll come back to this in a minute. But what he definitely has, though, is a mitigating factor that we had already alluded to when Doug was agitated by the fact that Bob had accused him of shoplifting. So mitigation, what would be a mitigating factor? Well, first of all, we want to make sure to talk about voluntary manslaughter. And remember what manslaughter is. Manslaughter is homicide without malice. Okay, so what we're looking at here under voluntary manslaughter is the particular defense of heat of passion. Now, what is it that Doug is going to try to argue? He's going to try to argue that he was reasonably provoked. I should say this. He was a reasonable person in his position would have been provoked to do what? Provoked to kill Bob? He was actually provoked. That's easily proved. He definitely was agitated. He did not. He has an inadequate time to cool off. In other words, a reasonable person would not have had an adequate time to cool off from being accused of such accusations, and he did not. He did not cool off, which we could say, coming back up to our facts here again, when Doug was falsely accused by, well, actually, this is what Doug believed that Bob believed that Doug had shoplifted, and therefore Bob had said about Doug that Doug had shoplifted, and therefore he twice falsely accused Doug of shoplifting. It doesn't indicate that immediately after being accused by Bob that Doug returned instantly to the shopping center or to the store. It's most likely there could have been some passage of time that would allow a cooling off. So quickly we could actually dispatch with this and say that voluntary manslaughter through the heat of passion defense would not work, because even though Doug was actually provoked, and he may not have actually cooled off, a reasonable person wouldn't have been provoked because of being twice falsely accused of shoplifting to kill Bob. And secondly, that the reasonable person would have had an adequate time to cool off. So we definitely do not, we can entertain our voluntary manslaughter argument through the heat of passion defense, but it would most likely fail. We want to make sure, though, to throw in involuntary manslaughter, criminal gross negligence. And this would be a substantial risk of life to the victim and those that are around the victim by the criminal activity of the defendant. Was the action taken by Doug in going into Bob's store and killing Bob by shooting him twice with a handgun posing a significant risk not only to Bob's life, but to the life of those around Bob in that small grocery store? Absolutely yes. So this very well could be, if Doug is able to mitigate his murder charge down, he would most likely be chargeable with involuntary manslaughter. So with this being taken care of, we have gone through a significant amount of elements. Pretty easy to be able to dispatch. Now, I would come back here and I want to point this out to you. We probably won't use the defenses because we've dealt with this down here under the heat of passion defense. So I'm just going to delete this defense here and pull this up. And now we have addressed the homicide of Bob. Okay, now going on to the larceny of the money. In larceny, it's the trespassory taking the personal property of another, with the intent to permanently deprive the owner thereof. When did this take place? And let's highlight the facts so we can easily see it. Come here and we'll come over here. This is when Doug noticed the cash register, went over and opened it and took all of the money out of it. Okay, let's see right here. Highlight that. All right, perfect. At this point, Doug has engaged in the crime of larceny by taking the money, because he trespassorily took the personal property of Bob with the intent to permanently deprive Bob of the money from the cash register. And you might be asking, well, could we bring up robbery here? No, that's an interesting question. But remember, Bob is no longer alive to appreciate the fact that Doug went over and took the money. And on top of that, he didn't take this money with force or threat of force. Although he did shoot Bob twice with a handgun, this would not represent that force or threat of force element. Okay, so we would stick just to larceny on this one. Now down under here, then we would say larceny of money. Absolutely, all the elements have been raised in our mind, and we've been able to put them on our paper, element by element, and proven each element by the facts. Okay, now going to the aggravated assault. Where was that? Let's go back up to our facts now. This is when Doug then saw a customer, Sally, hiding behind some shelves. So this is like Doug being alerted to the fact that there's another person in the small grocery store. He pointed the gun then at Sally, took her purse, and tied her hands behind her back. Well, when he pointed the gun at Sally, this is when I would see the aggravated assault. Remember, assault by definition is the intent by the defendant to cause a reasonable apprehension of receiving an immediate harmful contact. Okay, now remember here in this, there's also there's a couple forms of assault as well. And this, the one that we're bringing out, the aggravated assault. So there's the assault that brings about a reasonable apprehension or fear. There's the attempted battery assault, the incomplete battery assault, and then there's the aggravated assault type of assault. And because Bob is pointing a deadly weapon technically in the face of Sally, he has engaged indeed with the aggravated assault, the aggravation being the presence of the deadly weapon and pointing that deadly weapon at Sally. And then this would in a reasonable person in Sally's position would have a sense of fear in them, a reasonable apprehension. So could this crime be charged to Doug? Absolutely. So we're going to put that down here. Make sure that you want to put in a solid rule statement, and make sure that your rule statement in your analysis, the element by element is addressed fact for fact, okay? And make sure that to address these elements and facts as efficiently as possible, because remember, just going to kind of scan through here, time management on these probably more full essays, we call them racehorses, can be a little challenging, but if you get a good clip going in your essay writing, I think you can achieve that. You can achieve completion of the full essay in a 60-minute time period. Now, robbery of Sally. Now, when did this happen? Let's come back up and talk about that. This is when he took her purse. Okay. Now, Sally did not give Doug this purse. Doug took this purse from Sally. This represented the robbery. Remember, it would not be the larceny and the robbery. Remember, you can only be charged with one. It would most likely be the robbery. The robbery is what? The taking of another's personal property by force or threat of force with the intent to permanently deprive the owner thereof. And has he taken Sally's property? Absolutely. By force or the threat of force? Absolutely. And does he intend to permanently deprive Sally of her purse and the contents in the purse? Absolutely. So we could absolutely 100% say that Doug is chargeable with robbery. Now, when he tied her hands behind her back, this is when, coming down to our issues checklist, or our issue spotting list, we will talk about, we already established yes on this one, the aggravated battery. And that is when he tied her hands behind her back. Well, so remember, the aggravation is the presence of that aggravating circumstances, or aggravating circumstance or aggravated situation. Now, what would be that aggravating circumstance or aggravated situation? The presence of the deadly weapon. Okay, so this battery would not just be the general form of battery, but it would be an aggravated form of battery because of the presence of deadly force. So yes, we would have battery, but it would be a form of aggravated battery. And what is battery? Battery is what? Unlawful application of force to the victim. Now, to the victim's person. Now, has there been an unlawful, unjustified application of force to Sally's person? Absolutely. We come up here and we're going to look here. This is when he tied her hands behind her back. That is an application of force, unjustified, to Sally's person. Now, Doug then heard police sirens and ordered Sally at gunpoint out of the store and into his car. Now, I want to make sure to bring this to your attention. Ordered Sally at gunpoint out of the store and into his car. What's issue in our shopping or our issues checklist, or excuse me, that's just issues checklist, our issue spotting list, that those facts represent? Well, that would be our kidnapping. Now remember, kidnapping is technically false imprisonment plus movement. So it's the confinement of a person, of the victim's person, with no reasonable means of escape, plus the movement of the victim's person. Now, when exactly did the kidnapping occur? Let's go back up here. This happened when Doug ordered Sally at gunpoint out of the store. The movement itself from where Sally was positioned out of the store and ultimately into Doug's car represented the totality of the kidnapping. Now, that would be a sufficient set of facts to prove our kidnapping charge is definitely chargeable to Doug. So I believe that the state could appropriately charge Doug with kidnapping of Sally. Okay, now that would be a yes to that. Now we're going to look at the attempted murder of Officer Fran coming up into the facts now. Officer Fran, who was responding to a report of gunshots at Bob's store, saw Doug speed out of the parking lot in his car. Officer Fran chased him for several blocks until Doug pulled into an empty parking lot. When he got out of his car, Doug fired several shots at Officer Fran. Now this is when these set of facts here I want to bring to your attention. It's when Doug got out of his car and fired several shots at Officer Fran. This is the situation, the set of facts that represents the attempted murder. Why attempted? Because Doug took a substantial step. Now he basically had an intent, a specific intent at that. Specific intent to what? A specific intent to kill. We want to make sure that this is intent to kill because intent to kill requires an expressed malice of forethought state rather than implied. The others are either statutory or implied. Intent to kill is expressed, and it's this expressed intent to kill manifested by his firing of the bullets in the direction of Officer Fran that would represent the specific intent to kill. Had he then at that point taken a substantial step in carrying out the particular crime, what would be that crime? The homicide or the murder of Officer Fran, manifested by his intent to kill of Officer Fran through the deadly weapon. Did the presence of that deadly weapon and firing that deadly weapon in the direction of Officer Fran represent a substantial step? Absolutely. And we could even argue, if we want to, there's a proximity test as well. Which means the next proximate act, which would have been the bullets impacting with Officer Fran, would have brought about the death to Officer Fran. So we could very well say that even if the substantial step was not enough, we could very well say the proximity test could establish that Doug had gone from mere preparation to actual perpetration of the crime being intent to kill. Now, intent to kill murder. Now, remember, he may raise the defense of impossibility, meaning that he may try to argue a factual impossibility and legal impossibility. Now, under the legal impossibility, what Doug would be arguing is that what he was engaging in was not legally a crime, and therefore it was impossible for him to be charged with that crime. Well, intent to kill is a crime, so this particular defense, the legal impossibility, would not work for Doug. Factual impossibility, which is saying that, well, if the facts had been differently, I would have been able to carry out my crime, which would have been what Doug would say, that Doug would say that had the facts been different, he would have been able to carry out his crime. The crime being the intent to kill murder of Officer Fran. And that is never a defense. So even though we're going to raise factual and legal impossibility, these two defenses would not work for Doug. So now that we've addressed attempted murder of Officer Fran by Doug, and yes, he would be charged with that, so we're going to put a yes here. We're going to move now into self-defense. And this is where we're probably going to put this under the homicide of Sally. So I want to take this, copy this, and paste this. Remember, make copy and paste can be definitely the friend of an essay writer. Okay, good. So now, homicide of Sally. When does the homicide of Sally take place? Let's go back up to our facts. Okay. When Officer Fran was fired at by Doug, I should say when Doug got out of his car, Doug fired several shots at Officer Fran, who responded by firing her gun at Doug. Now, the response of firing the gun at Doug would represent possible self-defense argument here. So we want to make sure to come down and make sure we put a fact or two that are going to help us remember what the self-defense pertained to. So Officer Fran firing gun at Doug. Okay, good, right here. Now let's go back up to our facts now and really parse out our homicide of Sally. Now, when Officer Fran responded by firing her gun at Doug, she missed Doug, but one of her bullets went through a window of the car and hit Sally, killing her. Now, as this right here, and I'll put this in a different, highlight this in a different color for you. I'll try, let's see, red. Okay. Oh, let me undo that. Thank you for your patience. That didn't work out as planned. Let's try a different color here. Let's try green. Okay, good. This here would represent the homicide of Sally. Now, coming down now, we got to ask ourselves the same set of questions that we asked for the homicide of Bob. Was there a homicide? In other words, did Sally die? In other words, was there a killing of another human being by a human being? Yes. Was there an actual cause? Now remember here, actual cause being that but for test. In other words, but for the actions of Doug, the criminal conduct of Doug, would Sally have died by having a bullet enter the window and kill Sally? Or I should say this. Let me swap that around. Thank you for your patience. But for actually, you know what? I think I might have got that right. Thank you for your patience. But for Doug engaging in the criminal conduct, Sally would not have died when one of Officer Fran's bullets went through a window of the car and hit Sally, killing her. You could argue it just like that. So yes, is there a but-for test here? Yes. It hasn't been satisfied? Absolutely. Proximate cause. Is it foreseeable that a police officer who is responding to, let's take a look here, who is responding to a report of gunshots at Bob's store and who has been shot at by the criminal defendant, Doug, that she might respond by in self-defense by shooting bullets in the direction of Doug? Absolutely. And is it possible that during the commission, remember, we haven't reached a place of seeming safety, that safe harbor, so Doug is still engaged in a felony. We'll talk about that in a minute here. He's still engaged in a felony. Is it foreseeable that during the commission of that felony, the perpetration of that felony, that a death to the victim might happen? The victim being Sally? Yes. So we have foreseeability here. And then we're going to talk about malice of forethought. Again, with our four malice of forethought states. Now remember, we're going to bring up all 10 or all 4 here. Intent to kill. Felony murder rule. Intent to cause serious bodily harm, murder, and 4, depraved heart murder. Now, do we have an intent to kill? In other words, did Doug intend to kill Sally? Can it be argued that Doug intended to kill Sally? I don't think there's enough facts to indicate that, and there's not enough facts to indicate it or prove it. Now, Was Doug engaged in a felony? So we could definitely say no, we don't have it. We do not have an intent to kill aspect for Doug here. Okay. Now, was Doug engaged in a felony, and what felony would that be? Well, let's take a look up here. Now, what technically could we say concerning Sally that Doug has from Bob's grocery store has put into motion? A kidnapping. Okay, is a kidnapping considered a felony? Absolutely. So, and then on top of that, you could even argue, maybe even, that the modern law burglary is still in play. Okay, so modern law burglary and possibly the kidnapping of Sally could represent the felony. Could we supra? Absolutely, we could supra. Supra our rule statements. Make sure to supra your rule statements. This rule, absolutely, you could supra this rule. We're pointing this out so that we can address the elements. But absolutely good point. We could super our rules and possibly even super our analysis, making sure to add in those important facts that would help tell our reader that we're not just reiterating what's above. In other words, they call it supering to the finish line. We're not doing that. We're supering our rule statements and maybe supering some analysis. Yes, where is your murder rule exactly? We want to make sure to throw in. Oh, you know what? I appreciate that. Thank you for pointing that out. Absolutely, right here. We want to make sure to throw in a definition for murder. Very well done. Murder is the unjustified killing of another with malice of forethought. Okay, excellent job. Thank you for pointing that out, because this is of importance for our homicide, because not only is there a homicide, but we have a murder, which then goes right into our malice of forethought rule statement, or our malice of forethought element, which represents the rule statements that we're going to address. Now down here, under right here, so we could have both homicides be consistent. We're going to put in murder, unjustified killing of another with malice of forethought. Okay, now back to our felony murder rule. Do we have a felony that's being perpetrated, still in the commission, that has resulted in a foreseeable homicide to our victim, which would be Sally? Now remember what our definition for felony murder rule. You could super again what we already talked about above under the murder of Bob to save time. But if for sake here, we'll just say there's foreseeable homicide during the commission of a independent and inherently dangerous felony. Doug still in the commission of the kidnapping? Absolutely. Was it a foreseeable homicide of Sally that resulted from the commission of that kidnapping of Sally? Absolutely. And could we argue, and this is what we'd be under our degrees that we'll take up in here in a minute, that kidnapping, or we said maybe even modern law burglary, is an inherently dangerous felony? Absolutely. So we're going to bring up the inherently dangerous felony aspect later, but we have satisfied all the requirements for our felony murder rule, and even proven to some degree, and this is very well proven up from our facts right here, that Officer Fran has responded and to the report of gunshots at Bob's store. That Doug has not reached a place of safety, which means he's still in the commission of the felony. So Doug is still liable for all of the homicides that are resulting from this commission of the felony. The felony either being the kidnapping, the modern law burglary, or possibly both. Okay, now down here, so we have felony murder rule. Was there an intent to cause Sally serious bodily harm murder? I don't see it. But did the actions taken by Doug recklessly disregard the value of Sally's life? Absolutely. Absolutely did. In what way? Well, let's go back up here. The fact that he's engaging in the kidnapping of Sally, the fact that he had just committed a modern law burg, the fact that he's firing a bullets at Officer Fran, and the combined effect of all that is he has recklessly disregarded not only Sally's life, but those around Sally as well. Where do the facts about the police chase fit? Excellent question. Excellent question. This is going to be down under our mitigating circumstance. And remember what we talked about under the self-defense, Officer Fran firing a gun at Doug. This would be one of the justifications. Excellent spot though. This would be the self-defense justification. We'll just throw that in there right now. Oh, excellent job as well. Withdrawal. We could say possibly withdrawal, but the thing about it is we're looking at the self-defense, defense of others, defense of property. But we're seeing I don't see that as being a withdrawal situation. We could possibly bring it up. We could say that he was trying to withdraw we could possibly say that he was trying to withdraw. I'll put a question mark there. Yeah, he tried to run away, exactly. And so I'll put a question mark there. But if he was truly withdrawing, I don't know. I think you could argue that. You could say that the fact that he was driving away and the fact that he was chased, or that let's see here, driving away from. I'll just put it like this: driving away from the crime scene. Okay, you could argue that he possibly had engaged in the defense of withdrawal. But it could very well be easily defeated because a reasonable person in his position, you might argue that from a reasonable person, Doug, well, that's what I'm saying. Well, you know what? We'll come to that here in just a minute. But back up here under our depraved heart murder, has Doug engaged in depraved heart murder? Absolutely. He recklessly disregarded the life of Sally and those around Sally. Okay. Now, before we even get to defenses, we're going to talk about degrees. This is the cue, exactly right. We're going to bring in a lot of our facts from our cue to establish our elements. Yeah, it is in the cue, exactly. Let's go up here. We'll take a look again at one of the questions points out that we have some facts here as he tried to run away. Absolutely. We could argue that fact as being a withdrawal by Doug. Excellent point. Very well put. You can get in and address that particular issue and then make sure to address it and then move on from that issue and be able. Yes, absolutely. Very nice. Very well done. Okay, down here under degrees we have first degree murder. Okay, now under first degree murder, remember we talked about up under Bob we had premeditation, deliberation for intent to kill. Well, under felony murder, we have inherently dangerous felonies. Now remember, we have felony murder rule apply here. Why? Because Doug was engaged in either, and I would say both. You have the modern law burglary and the kidnapping of Sally. And both of those represent what are inherently dangerous felonies. And inherently dangerous felonies are inherently dangerous by statute, which is the ones that we have, or by commission. Commission would be like lying in wait, torture, and bomb. We don't have any of those types of situations. But we do have inherently dangerous by statute. And so has Doug engaged in one of those? We already proved that. Absolutely yes. So could it be possible to charge him with not only felony murder, but first degree felony murder at that? I would possibly say yes to that. It is likely he could be charged with that. Now, second degree, like we said above, residually defined, all malice of forethought states not in first degree or in second degree. What is it we could put in here? Our depraved heart murder. So even if it were not possible to prove up the inherently dangerous felonies, which would then even have our felony murder, you could say, oh yes, thank you. Or we would have our first degree felony murder being brought down to a second degree felony murder, but we could also say for second degree that we have a depraved heart murder second degree. Okay, now addressing the defense of withdrawal, we could say that Doug was driving away from the crime scene. Remember, the facts state that it wasn't just the crime scene. He was trying to run away. As Doug tried to run away, we could argue that in a withdrawal argument that his driving away could represent his withdrawal, and then we would get in and we would get out of that particular issue. After then going through that defense, the issue of withdrawal, the defense of withdrawal, we would now go down to the justification of self-defense. Why we say self-defense? Because Officer Fran was firing a gun at Doug. Where is that in our queue? Let's go back up here. As Doug tried to run away, Officer Fran tackled him. Okay, tackled him and knocked the gun from his hand. Now, you might be asking yourself here, is this indeed a self-defense situation? Because remember, how did Doug respond to this? Doug got up and punched Officer Fran with his fist. Now, Doug is technically resisting lawful arrest here, but on top of this, he's saying, well, my life is in a self-defense argument, he's going to try to argue that his life is about to be imminently taken. Well, if that were the case, the gun that was knocked from his hand did not cause his death, okay, and did not cause, okay, in other words, I need to put that a little bit better. When Officer Fran tackled him and knocked the gun from his hand, Officer Fran knocked away the deadly force presence from the situation. So what Doug was going to then get up and punch Officer Fran for was technically a non-deadly force. The fact that Officer Fran tackled him, I'll highlight this for you here, tackled him and knocked, I'll just put the word knocked in here so we keep this, so tackled and knocked the gun from his hand. Okay, so we have the fact that she is not engaging in any deadly force; she's engaging in non-deadly force, and we have to understand in self-defense there has to be an immediateness to the threat of life, and you have to face the force that you're facing. You have to face that force with proportionate force. Okay, is Doug facing that force with proportionate force? Well, in essence, he gets up and he punched Officer Fran, but remember here, he's resisting arrest too, okay? Is he going to try to say that in resisting arrest that he was defending himself? You could argue that, but was his life in immediate danger? No, and that's why this defense will fail. So this is going to be a no-win defense for Doug. But now, is that where the story ends? Can Doug bring up something else to mitigating circumstance? Absolutely. What's he going to try to bring up? Absolutely, heat of passion. He's going to try to say, now remember, we're going to bring it up here, voluntary manslaughter. Oh, let me try to spell that right. Okay, there it is. Okay, voluntary manslaughter. He's going to try to say that he was heat of passion offense. Now, in a heat of passion offense, would a reasonable person have been provoked to what? Reasonable person being provoked to hit Officer Fran? No, a reasonable person wouldn't have even been in that situation anyway. Did he have enough time to cool off? Would a reasonable person have had enough time to cool off? Well, see, that this is a very close argument here. I think what he might be trying to say is that his mitigating circumstance of the heat of the situation represented a mitigating factor. Now, the mitigating factor, I think we're trying to. I'm not trying to circle around here, but is the provocation. But he wouldn't be reasonably provoked because a reasonable person would not have been involved in that criminality in the first place. So this defense is a no-win for Bob, or for Doug, excuse me. But now we have another mitigating circumstance under a mitigation argument under voluntary manslaughter. And what is that? That would be imperfect self-defense. The imperfect self-defense is that honestly but unreasonable belief that your life is about to be taken, or that there is a need for self-defense. Essentially, could Doug honestly believe that he needs to defend himself by getting up when he got up and he punched Officer Fran? I'll highlight this for you here. When he got up and punched Officer Fran, that with his fist, let me highlight this, the whole thing for you, so that you can see it in its completeness. Thank you for your patience. Would he honestly believe that his life was immediately about to be taken, or there was a need for self-defense? You could argue that it could be an honest belief. Was it a reasonable belief, though? No. So it's possible. It's a possible argument to mitigate his murder charge down to voluntary manslaughter. It's possible, and I'm going to put a maybe. Now, down here that we're going to look at is the involuntary manslaughter. We don't want to forget to keep with our what we call as our template in all of our issues, because all of our issues have an approach, and that approach would be called a template. And each one of these follows a predictable issue element format. Why? Because our readers have expectation. What is that expectation? That the issues be presented in a logical format, in an orderly format, and that every element be supported by a what? A fact. So these facts are important to prove up each and every element of our not only our from our shopping list, but our templates and then the elements from our issues. Make sure to support those with the facts. Okay, back to our discussion here. Involuntary manslaughter. Involuntary manslaughter. Remember we talked about this, the gross criminal negligence. Did the actions taken by Doug, let me make sure to spell that correct. Okay, thank you. Did the actions taken by Doug when he was engaging in the kidnapping of Sally represent a significant a significant risk did it represent an activity that poses significant risk to the life of not only Sally but those around Sally? Absolutely correct here, because not only did Doug fire shots, or did not only Officer Fran respond to a report of gunshots at Bob's store, but now Doug is firing bullets at Officer Fran. Officer Fran is firing return bullets at Doug, and one of those bullets went through a window of the car and hit Sally, killing Sally. So would the whole situation that the criminal conduct taken by Doug represents a significant risk to the life of not only Sally but those that are around Sally? Absolutely. And so we could argue that is a support for our factual support from our Q for our involuntary manslaughter, criminally gross negligence. Yes. Now the battery of Officer Fran, we can super our rule statement up above for battery at subtracting out the aspect of the aggravation. So it's unjustified application of force to the person of another. Would Officer Fran be able to bring this against Doug? Absolutely yes. Why? Let's go back up to our cue to make sure we understand that we're on the same page. On this. When Doug got up, he punched Officer Fran with his fist. Officer Fran then subdued and arrested Doug. So when Doug got up and punched Officer Fran with his fist, that was the fact, or the facts that represented support for our battery of Officer Fran. So now when we go into our conclusion, we're going to do I'm going to throw this in a bracket here. This is more of a summary, a wrap-up of sorts of all of the elements, all of the, I should say, the big topics, the big issues that we've addressed and the results of those issues. So let's go through here. And as we go through, this is what we put into our conclusion. Therefore, or in conclusion, Doug could be charged with what? Up here. Could he be charged with Go all the way to the top here. The burglary of Bob's store. Yes. Through modern law burglary. So we'd say the modern law burglary of Bob's store. Homicide of Bob. Yes. Larceny of the money. Yes. Aggravated assault of Sally. Yes. Robbery of Sally. Absolutely. Aggravated battery of Sally. Yes. Kidnapping of Sally. Absolutely. Possibly attempted murder of Officer Fran. Yes. Homicide of Sally. Without a doubt on that one. And battery of Officer Fran. Yes. And then we want to follow it up with an additional statement concerning defenses. Does Doug have any defenses he could bring up? Well, it does. Even though he might be able to bring up some defenses, those defenses appear weak, and possibly not viable in a lot of situations. Like, or like for instance, the situation involving homicide of Bob, there really wasn't a defense up here, except for possibly heat of passion, which failed. So that wouldn't work. I was bringing up in our conclusion. Under the homicide of Sally, was there any defenses? Possibly withdrawal, possibly maybe the imperfect self-defense argument, maybe that. And that would represent our conclusion, the likely result from our analysis. I hope you had a great time going through this essay number 3. All right, bar applicants, excellent job, and I'll see you on the next podcast. Make sure to check out my Kindle book on Amazon Kindle, Battling the Big Bad Baby Bar. I thank you so much. Have a great day, and best of luck on the bar exam.